Let us start today's discussion, that is 30th January 2016. Now the first article is related to the content of court. Article 19(1)(a) provides for the freedom of speech and expression. Article 19 subclause 2 provides for the state to apply certain reasonable restrictions on the freedom of speech and expression. Under Article 19 subclause 2, that contempt of court is also a reasonable restriction. In the Constitution Assembly discussions, Pandit Bhargava, Thakur Das Bhargava, has opposed introduction of the contempt of court as a reasonable restriction under Article 19 subclause 2. His argument was it leads to the judicial overpower, and any constructive criticism of judiciary can be constrained use of this reasonable restriction. And freedom of speech and expression, it's a virtue in itself, and it shall not be restricted by very much the enforcer of the rights of the people, that is judiciary. So in this case, to give effect to this constitutional article under 19 subclause 2, in 1971, Contempt of Court Act was passed by the Parliament. What this act says is there are three conditions under which contempt of court can be issued. One is anyone scandalize or lower the authority of any court, prejudice or interfere with the judicial proceedings. The third one is interfere or obstruct the administration of justice in any manner. These are the three things. So the second and third, that is prejudice or interfere with the course of any judicial proceedings and obstruction of justice, these two are very much necessary for the rule of law. But the first one is the scandalizing the court or lowering the authority of the court. It is more the insecurity of the system rather than majesty of the institution. So in these circumstances, in 1996, the Supreme Court has given a judgment which says that any statement or any act that brings disrespect or disrepute or which offend its dignity can be challenged, or else can be in a contempt of court can be issued. So there are disrespect, disrepute, lowering the authority of the court, and bringing down its dignity. Any of these things are done by a statement or an act, then automatically it brings down something called as a contempt of court. So in this context, the Contempt of Court Amendment Act was passed in 2006. It tries to give two protections to the citizens against the misuse of this contempt law. What it says is, now it has to be established that any contempt before it is issued, it has to, that particular action of an individual has to obstruct the delivery of the justice. That is the first protection. Second is, the truth can be taken as a defense against the contempt of the court. So these are the two protections given by 2006 amendment. But most of these are not observed in issuing the contempt of court notification by the judicial system. So here we can finally argue it this way. In England, where we brought this contempt of court from, no contempt of court was issued against an individual for criticism of judiciary. But in India it is widely misused and the freedom of speech is restricted to such an extent. In a recent case, Arundhati Roy was issued the summons by the Maharashtra court or Mumbai court, Nagpur bench of the Mumbai High Court on this particular matter. So it means we have to curtail this contempt of court. Next is, with regard to the Unnatural Crisis, let us see what are the constitutional articles in discussion. The Unnatural Crisis case, High Court of Guwahati, it has upheld the decision of the governor. So why it has upheld the decision of the governor? Already in the previous videos we saw what was Unnatural Crisis is. Now in this case, Article 163 of the Constitution, It talks about the discretionary powers of the governor. And the greatest discretionary power of the governor is to decide on its own discretion, or what constitutes his discretion. And Article 174, 1 of the Constitution, it provides for the responsibility to the governor to summon or prorogue the assembly. And Article 175 subclause 2, he fixes a specific term and agenda to a session of the legislature. So, but however, in reality, Article 174(1), Article 175 subclause 2, it has to be undertaken on the aid and advice of the Council of Ministers. So, next one is Article 356 and its imposition. So it is considered, it was considered as a dead letter by the Dr. B.R. Ambedkar, but it became the most misused provision. So in S.R. Bommai versus Union of India case, the Supreme Court has given out certain safeguards against the misuse of Article 356. But how, in spite of this, the ruling regimes, they have their own reasons at the center to circumvent these provisions and to impose this particular emergency, that is state emergency. So in this context, how we have to safeguard the democratic system from this? So first thing is, a floor test has the basis. But if the Chief Minister and Council of Ministers do not advise the governor for a floor test or for summoning of a particular session, so then governor shall write it to the president of the party. So who is the alternate leader? So in these circumstances, so the responsibility has to exist. A must responsibility has to exist on the Council of Ministers to summon the House, and governor shall use all the alternative mechanisms before delivering something called as or recommending for something called as President's rule. The next is spectrum pricing. Now in any public resource, if it is excessively priced, that leads to the increase in cost and underutilization of the service by the people, ultimately reducing the benefits or profits and penetration of the technology. Now, recently, the TRAI has decided 11,500 crore rupees for 1 megahertz of the spectrum to be sold. That's a very higher price. So, in this context, the very purpose, financial viability of the industry and the cost of the service to be used by the citizen, everything will be worst affected due to these high prices. And the TRAI in the past failed to realize the value when the prices are very high for the spectrum. The next is the smart edge. We know that Union Ministry for the Urban Development, it has released 20 smart cities. So many states, for example, Telangana, UP, all these accused that they are not given a space with regard to the smart cities, and smart cities are politically motivated. But however, the ministry clarified that an independent agency consisting of the foreign and Indian experts has decided on the merit of a case with regard to smart cities. Now in urban India, the governance is a chaos. What the smart cities aims to bring in, they are going to provide for a virtual business districts everywhere through use of technology. So in this case, Urban Minister has defined a smart city as this way, which enables a decent life to its citizens and provides for green and sustainable environment, enables adaptation of the smart solutions. So here the smart solutions is the most important. Now under this, the government will give 500 crores of the seed capital, where the states have to substantiate that with another 500 crores. And after that, the remaining money has to be mobilized by the local government by itself. And there is public-private partnership mode is suggested for this. So in this case, many states have given many innovative solutions to improve the urban connectivity, especially the urban transport. If you talk about Bhubaneswar and Ahmedabad, they brought in common travel card. They suggested for common travel card. Added to that, Few other cities have provided for improving the walkable spaces and also the use of public transport rather than encouraging the private transport. And public buildings will get a uniform design now, which can provide with the disabled access. So finally, the smart cities one, it also tries to provide for improving something called as adaptation of the best practices and civic upgrade wherever they are being implemented in the country. Next is, this is the most important, universal health coverage. So providing the universal health coverage is a goal under the Sustainable Development Goals, it is 3.8. So the universal health coverage, under the Sustainable Developmental Goal, it failed to stress an important factor that is called as quality of healthcare delivery. So in this case, a special body or special unit will be appointed to monitor the quality of healthcare services. So the special unit has three responsibilities: alignment of country engagements with the global framework, health service resilience, and quality, and establishing the partnerships to reach to these goals. So one is alignment of countries' engagements with global framework, health services resilience and quality, establishing partnerships. So in this case, I try to remember this health services resilience. Now, if you know that Zika virus which is going on, and added to that, you have Ebola breakdown. So this, how to respond to this, that is called health services resilience of the particular country. And next is, another term which is used is the social determinants of health. If you want to achieve the universal health coverage, you need to understand what are the social determinants of the health. You need to fight at that particular level. Coming to the urban poor. So now, previously there was a question in UPSC which states that the conditions of the urban poor are much worse than the rural poor. Now this NSSO survey, it squarely fits into that statement. If you observe the asset owning at the urban level and the rural level, the poor people, that is the rural poor, they own the greater assets compared to the urban poor. And added to that, interstate variations are also very high among the poor people. So in this context, if you take about Odisha, it has got the lowest asset value for an urban poor, and on the other hand, Haryana has an highest value for the urban poor, asset value for the urban poor. So it means the rural-urban differences, especially with regard to the poor people, the vulnerability is high for the urban poor. And the next is the debt on the head of an urban poor. It is almost 2 to 3 times higher when compared to the rural poor. So in this context, there are also no programs specifically directed at the urban poor, and identification of the beneficiaries among the urban poor also very difficult. This makes urban poor more vulnerable for crisis rather than the rural poor. So these are the articles for today, and all the best. Thank you very much.